So, another area of our lecture would be corporate law. And as exactly we found out that the business sector in India during the British rule, as it was initiated by the Britishers and to some extent by some of the private players of India like the Tatas or Birla and the very companies, those who played vital role in increasing and expanding the business sector in India. So, inconsequently, with the thousands and thousands of players in the business sector or the industrial houses and business houses, the government of India, after independence, enacted the Companies Act 1956. And that Companies Act of 1956, which was regulating the very formation of companies and the very incorporation of companies and the management and regulation of companies and their dissolve and wind off, and also the very role played by the shareholders and their respective rights and the management of companies in consequent to expansion of industries and the roles played by new industrial and emerging business sector and the new players in India's economy, and also the very role played by some multinational corporations who entered into India's business sector or industrial sector. As regarding to that, as India adopted the very policy of liberalization in the 1990s, when Prime Minister, the then late Prime Minister V.V. Narasimha Rao, who initiated the very policy of liberalization in economy, and it was carried out by the then finance minister and also then the Prime Minister of India, Dr. Manmohan Singh, the very backbone of business operation of India, which would be regulated by the Indian Companies Act, which was amended in 2006, and consequently it was amended further in 2013, and the very act provided a set of rules and regulations that govern how companies are formed, managed, and dissolved. This body of law covers a wide range of topics, including companies incorporation, corporate governance also the shareholders' rights and the very question of mergers in between the companies and acquisition of companies by one company of acquisition of another companies and the regulatory compliance. So, the very corporate law of India originated out of the developments and the evolutions in the business and industrial sectors and due to the developments and changes and amendments made in the Companies Act of 1956 in the year 2006 and subsequently in 2013. So, understanding Indian corporate law is crucial for business to operate legally and effectively in the countries. Which country, that is India, is having a dynamic market. So, for understanding the very Indian corporate law, we need to discuss scenario which are falling under the corporate landscape of India. So, in that regard, we would like to discuss certain important provisions relating to the Companies Act 2013. And in regards to that, we found the very basic and fundamental provision under the Companies Act 2013 is relating to formation of companies. So the very act itself provided the procedures and requirements for the establishment of various types of companies including private limited, public limited, and one person companies. And now we'll discuss about the very corporate governance. And corporate governance refer to the system of rules and practices by which companies are directed and controlled. So the Companies Act 2013, along with those guidelines issued by the regulatory bodies which are coming under the Companies Act, like the Securities and Exchange Board of India, which is mostly known as SEBI, set out principles for corporate governance. So these include broad composition, shareholders' rights and disclosure norms, ensuring transparency and accountability. And now we'll discuss the very provision in regards to shareholders' right. So, as per the provisions of the Companies Act of 2013, shareholders as owners of the company enjoy certain rights and protections under Indian corporate law. These rights include voting on key company matters, receiving dividends, and assessing important company information. Shareholders also have a right to inspect company records to ensure transparency and fairness. And another important area that we would like to go is the very compliance and regulatory requirements. And exactly in regards to the regularity requirements, we found as per the provisions of the Companies Act of 2013, the first one, the requirement of annual general meeting, then issuing a financial statement, audit and auditor's appointment, the board meeting, board's composition, corporate governance, and regarding annual returns. So also the related party transactions and compliance certificates. So also the compliance with CSR provisions. So the very compliance and regulatory requirements as per the provisions of the Companies Act 2013 provides annual general meeting. So companies are required to hold an annual general meeting within 6 months from the end of the financial year and not more than 15 months from the previous annual general meeting. Annual general meetings are crucial for shareholders to discuss company matters, approve financial statements, appoint auditors, and declare dividends. So also, the other regulatory requirements includes financial statements, so companies must prepare and file annual financial statements including the balance sheet, profit and loss account, director's report, auditor's report, and other documents within prescribed timelines. And another regulatory requirements under the Companies Act of 2013 is regarding auditor's appointment, and companies are required to appoint statutory auditors to audit their financial statements annually. The auditors must be appointed at the first annual general meeting and therefore through shareholders resolutions. And another requirements that is also regulatory requirements under the Companies Act 2013 is regarding board meetings. Companies must hold board meetings at regular intervals at least 4 times a year to discuss and decide on various matters concerning the company's operations, finances, strategy, and compliance. And now we'll go to another regulatory requirement under the Companies Act of 2013, that is the regarding the very composition of the board. So the composition of the board of directors must comply with statutory requirements regarding the appointment of directors, independent directors, and women directors. Also, another regulatory requirements under the Companies Act 2013 is regarding corporate governance. Companies, as per the provisions of the Companies Act 2013, must adhere to corporate governance norms, including the constitution of board committees such as the audit committee, nomination and remuneration committee, and stakeholder relationship committee. And another regulatory requirements under the Companies Act 2013 is relating to annual returns. So companies must file annual returns with the register of companies containing information about the company's share capital, directors, shareholders, the annual general body meetings, and other statutory details. And also, another regulatory requirement under the Companies Act of 2013 is relating to companies are required to disclose and seek approval for related party transactions that may impact the company's financial and governance. And the next regulatory requirement is that certain companies, based on their size and nature of operation, are required to obtain compliance certificates from practicing professionals verifying adherence to various legal and regulatory requirements. And finally, as per the provision of the Companies Act 2013, qualifying companies are required to comply with corporate social responsibility provisions, including formulating a corporate social responsibility policy, constituting a corporate social responsibility committee, and spending on the very activities of the corporate social responsibilities. And now we'll discuss exactly what corporate social responsibility means. The very Companies Act of 2013 mandates certain eligible companies to allocate funds for corporate social responsibility activities. These activities aim to contribute positively to society and the environment, reflecting the company's commitment to social welfare alongside its commercial objectives. So, corporate social responsibility under the Companies Act 2013 is a significant provision that mandates companies to contribute to social development. This provision was incorporated to ensure that business not only focus on profit making but also fulfill their responsibility towards society and the environment. And in that connection, we found many of the corporate sectors, such as the Bhushan Steel Plant or the ArcelorMittal or the Tata steel plants or the power plants established by either Tata's or Jindal or by the cement industries where we found the Birlas, even the Jindal sector. While establishing their factories and industries, by cutting down trees, they are laid down the responsibilities for plantation of trees in those areas and even in the nearby mountains and hills and plantation of other different kinds of environmental friendly trees. So these are the different activities falling under corporate responsibilities. So, under the Companies Act 2013, certain qualifying companies are required to spend a percentage of their average net profits on corporate social responsibility activities, and these activities typically include initiatives related to education, healthcare, environmental sustainability, rural development, and other areas that benefit society at large. So, in that connection, we found in India, especially in the field of education, some important corporate houses and business sectors such as Vedant and also the Birlas, the Jindal, and also even the Tatas, they have spending crores of rupees in the field of education, so also in the field of healthcare. The Tatas initially as the beginners in India's corporate sector, they established the Tata Cancer Institute at Bombay. So, also other different corporate sectors, they are playing their contribution in the field of healthcare. And at present, we found many of the players in corporate sectors, they are contributing from their net profit in regards to sustainable development, in regards to environmental, to check climate change or global warming, or in regards to preserving biodiversity. So also, some of the corporate sectors, they are playing vital role in the field of rural development. So, as per the Companies Act of 2013, not all companies are required to undertake corporate social responsibility activities. The corporate social responsibility provisions apply only to certain categories of companies based on their size, turnover, and net profits. And in this regard, would like to discuss in regards to their size turnover. We found certain important corporate sectors like the Jindal Steel and Power companies and also the ArcelorMittal companies and Nippon Steel and also the Birla's Cement and also the Tata's Steel and Iron and other such associated industries. So, in the last decade in India, besides the corporate houses and industries in India, like the Reliance and the Adanis in the field of petrochemicals or in the field of transportation or in different other fields, they are playing vital roles. So, the Companies Act 2013, in that sense, its very provision in regards to corporate social responsibility is vital, as because it would compel those big houses, industrial houses, and corporate houses to contribute in the field of development of education, healthcare, environment, and for rural development, as almost all the industrial houses, they are entering into such ventures which are causing damage, destruction of forest, natural resources like river, lake, and forest, and wildlife resources. So, the very provisions of the Companies Act 2013 definitely made such a provision in regards to corporate social responsibility, which would make a balance in socio-economic development and an overall development of India. And so, we would like to conclude our discussion on corporate law in India. So, the corporate law in India played a crucial role for businesses, ensuring they operate ethically and within legal boundaries. By embracing its principles, and companies will trust, manage risks effectively, and foster sustainable growth. So, the companies are corporate houses as per the provisions of the Companies Act 2013. They must respect those principles developed and evolved in regards to sustainable development in the 1972 Stockholm Summit on environment, and also in the 1992 Earth Summit of Rio de Janeiro at Brazil in regards to climate change and sustainable development. So, the Kyoto Protocol of Japan, where also the very emphasis was laid on the very principles of sustainable development, and also the 2002 Johannesburg summit, where finally world emphasized on the implementation of the principles of sustainable development developed by the Grand Commission in 1987. Those principles as the polluter pay principle, the precautionary principle, the no fault liability principles, and finally the public trust principles. And in regards to that, these principles were applied by the various courts in India and even in United States of America in regards to corporate social responsibility. So in India in particularly, in many number of cases, and to mention a few, we could cite the very example of the Bhopal gas leak tragedy, and also the case of Shram Fertilizers oleum gas leak case of Delhi. So also we could cite in international case about the monologue case of California, and also the most important decision delivered by the United States of America's Supreme Court in the important case relating to the state of Illinois. So, in all these cases, if you would like to study in detail, you would found about corporate social responsibility, and in particular in regards to the provisions of the Companies Act 2013, we found the very provisions of the Companies Act of 2013 clearly made it mandatory for all the corporate business sector and industrial houses to fulfill their corporate social responsibility. So, in our upcoming lecture, we would like to discuss those important questions and answers that we have framed in regards to complaint law.